estate planning attorney, and we're going to get started in about 1 minute. We had a couple more people sign up. I'm just going to wait until give them another minute. What I am going to do is I will mute everybody for now, but don't worry. If you have a question, you can either type it in the box or you can unmute yourself if you'd like and ask me the question. I will definitely open up for questions at the end as well. But if you have thoughts and things as I'm going over different concepts and ideas and thoughts, then feel free to type it in the chat, and I promise I will address it. And just kind of like some background or just some logistics. This is about an hour presentation. Sometimes it'll go over an hour to, it's between an hour and a half, depending on questions. And so that's the most of it. So that's all you have me for today, if you can take it. The goal is to go over basic information and understanding of the key things you need to know about estate planning, common pitfalls that I see. I've been doing this. I've been an attorney since, 96 now, almost 30 years, like 27, 26 years, and estate planning for the past 20 years. And what I'm going to be showing you is kind of where we're at, the latest and greatest that we feel as far as on the estate planning side, the things to be considering. It is education, the goal today. And so this sheet I have for you, you have this, you should have received this as part of your packets, is selecting and working with an estate planning attorney. These are the questions that I would be asking an estate planning attorney, knowing what I know. Everyone asks about price, and we'll talk about price, don't worry. But there's about 14 other questions you should be asking your estate planning attorney. And so I'll go through that, like how we do that. And I'll check back in later and kind of go back in toward the end of the presentation and check and show you the answers. So hopefully you'll understand why we're asking the questions, and you can do your own due diligence and arm yourselves. So with that being said, I'm going to get started. I'm Bobby Feisee. I'm president of Insight Law, and we do estate planning and business planning. We have a team of 10, 4 attorneys, 6 support team members, and I'd say our practice is about 60 to 70% just focused on estate planning, and then 30 to 40% business planning, just depending on the mix of the clients. I'm a very blunt attorney. Most estate plans just don't work. How would you know if your plan worked or not, right? Maybe when would you know might be a better question. And so this concept, or this idea of a snapshot test is, we're here to learn about estate planning. So I want you to visualize the time after you passed away and you're looking down from your cloud from above. All my clients look down, they don't look up, right? Beats the alternative. But if money's going where you thought it'd be going, and people doing what you thought they'd be doing with it, then that's generally a plan that worked. Money's not going where you thought it was going, things not happening, things tied up in court or frozen assets or taxes or things like that, people fighting, probably a plan that didn't work. And so, you probably have an idea how you want things to kind of run. My goal today is to kind of give you, clarify that picture for you so you know all your options. I just find people don't know all their options. And they get distracted by these smoke screens. So one smoke screen is focusing on just the documents, okay? What documents do I need? I need a will, a trust, medical director, power of attorney. And my point of why that's a trap, or that's why that's it could be a smoke screen, is that the focus is on the documents rather than what we're trying to accomplish here, right? The documents are important, and my analogy is this. If any of you seen the show The Fixer Uppers, Chip and Joanna, if you haven't, they're basically a couple that goes and renovates houses. Joanna's the one that sits down with the clients and gets their vision and their goals. How do you want the kitchen to look and feel, bathroom, bedroom, and those like. And Chip is the carpenter. He comes in with the tools and implements, okay? And so my analogy with that in estate planning is, does anybody ever ask the carpenter or ask Chip what tools he's using? No, right? I mean, I want the kitchen to look like this, right? Feel like this. They don't ask, which tool you use. And that's the same analogy with the attorney. Our tools are our legal documents, okay? Yes, we'll go over what trusts are, what wills, medical directives are. But which combination is right for you? It just depends on your situation. And also, when our mission in our firm is pretty clear. We have a business plan, we have a mission, and our mission statement is, when we get that call when one of our clients passes away, we want to be able to say everything's in good order, just be with the family. When you're ready to come in, we'll lay out the next steps, right? They don't, if you just have some documents, they're not going to jump off the shelf that does things. And or if you call the attorney, we think everything's in good order. We don't know. We haven't seen you in a while. We haven't updated the docs. We're not sure. And so it's really the process and making sure that whatever your goals are gets implemented. The tools are the documents. So just don't focus strictly on the tools is what I'm saying to you. They're important. We'll go through them, but don't just focus only on them. The next thing that I find are people get a smokescreen is just focusing on taxes. I don't need to do estate planning because my estate is not subject to estate tax. We will talk about estate taxes. Estate taxes right now do not impact a lot of people. It's the exemption, or I call it the coupon, is as high as it's ever been. We'll talk about that. But that's just one sliver of planning. That's the estate tax. There's also issues. There's been updates on the income tax side when it comes to estate planning, right? So most of my clients have IRAs, 401ks, retirement plans. Legislation was recently passed, and new legislation just in December called the Secure Act 2.0 now. They had 1.0, 2.0. That impacts all retirement plans, right? And when you write that beneficiary designation on your retirement plan, that's estate planning, and they just changed the income tax rules on that stuff, okay? And so you just need to be aware, and so a lot of people can't keep up with that, but the idea is to make sure your plan is still on track, that those designations are still accurate, because a lot of wealth is usually concentrated in our clients' retirement plans. And so taxes rears its head in different areas, and it's not the sole purpose, but it's one of the check marks that we look at, right? And then the transfer trap, and that is, I just want to avoid probate, okay, whatever that is. And what a probate is basically a government audit of your affairs after you die. They want to know to the penny what you die with. They want to track all the income while the assets are tied up in probate, notify all the heirs and creditors, let them all fight it out, and then afterwards you can pass the assets on to the beneficiaries. And yes, the courts are slower now. Even that we've passed by the pandemic, we've got a couple of years under our belt. Still slow, still backed up. And so it can be avoided, but that's one of the goals. And that's definitely one of our goals is that's baseline goal. Okay. But if that's your only goal, I'll show you how to do that today without any legal documents. So you get that for free. But what I find what's really missing is people knowing all of their options. Working with a firm that counsels them, goes through their specific situation, pros and cons. And so, a lot of times they're just people getting here's some biographical data and people getting some forms spit out at them. And I'm saying to them, if you're just getting that, then just go to LegalZoom. If they're not getting any advice right above that, the attorney should bring that to it. So I find a lot of people don't have an idea of what options to choose. And if you go to LegalZoom, you don't know which buttons to pick, right? So it's all fuzzy. So again, I'm trying to clarify that for you. So let's begin with the basics. If there's nothing else that you remember from today, I would say I would remember the definition of estate planning. And I like our definition. It comes from the National Network of Estate Planning Attorneys. I'm an instructor there. The reason why I like it, it covers all the issues, okay? It's not going to be in Webster's Dictionary or Black's Law. I think it's good. And so it goes like this. I'm going to control my property while I'm alive and well, right? A plan for me, my loved ones, if I become disabled, mental disability. So estate planning is not just death planning. We just hopefully you'll never have to deal with a disability, but this is there to protect against a disability, that we have some type of plan in place. And then I want to give what I have to whom I want, when I want, in the way that I want. And I find a lot of people don't know the different ways they can leave their wealth or their assets to their loved ones. And then all while assuring my wisdom is transferred along with the rest of my wealth. So we try to set the bar high. Let's pass the material wealth. If there's opportunities to pass on some non-material wealth, some life lessons, some values, this is the place to do it. All the best gifts that I've ever received, and there's a nice little note that goes along with it. And so that's the definition. That's what I think of, and I think it covers the issues. And our approach to it, okay, every attorney has a different approach. I like our approach. We use this planning pyramid approach where we go through the issues and we categorize them and with the most important issues towards the base of this pyramid, and we just walk our clients up to the top. Get to know your situation first, right? You, me. We want to know what your hopes, fears, concerns are, what your specific situation is. Then we go to the family. Are you married or are you not married? If you're married, how is the spouse's health? What are their fears, hopes, fears, concerns? If you have kids, are the kids minor children or are they adult children? Whole host of different issues for minor children than we have for adult children. And then, just because minors can't inherit money, even though you're 18 years old, does that mean that that age means that you have all the experience you need to manage the wealth and the like, right? And so what about if the beneficiaries are, how are their marriages? Strong, shaky? Do they have any creditor issues that to be worried about, right? And so you just want to, or health issues. So is there a health concern? Is there a special needs issue? So once I know the lay of the land, the family dynamics, then we can go ahead and start presenting ways and strategies to preserve wealth, expand wealth even, and save taxes. But I find a lot of people just start with this tax strategy to get people in the door. And I'm like, that's, the tax strategy, there's a lot of different tax strategies. Which one's going to apply to you depends on a lot of different factors. And if I don't know you and I'm just presenting this strategy, that's very dangerous. Okay. And I think there's other players in this field that makes the plan stronger. If you have them, if you have a financial advisor, they will bring a lot of value to the table to preserve wealth and expand wealth. And when an estate planning attorney and the financial advisor are working together, that makes your plan stronger. And, making sure that your tax advisor is involved, and just depending on the level, just knowing that what to do on those issues. So that's the idea. And the idea is that you teach us about the family, we'll teach you about the law, and together we'll make the plan work. Okay, we'll co-create the plan. And I review a lot of plans. A lot of people ask me to review their plans, and this is really my bullet point checklist. I'll go into what they all mean, but this is I see, did these people get personalized counseling, or is this just a word process document? And yes, I spelled counseling with 2 L's. Again, the attorney should bring something more to the table, and we'll get into some of those some examples of that. And then this is another critical one, and a common pitfall, okay, for estate planning that I find is making sure that all their assets are properly titled. Okay, so a lot of times people have these instructions that are placed out there in their wills and things, and their assets are titled where things are going in a different direction. Okay, so estate planning is about having a great set of instructions and making sure that your assets are titled in a way that the instructions will actually apply. Because there's only 3 ways you can own your assets. It's in your individual name, jointly, and by contract. That's it. Okay. And people get confused about the contract ones. We'll talk about those. IRAs are contracts, 401ks are contracts, trusts are contracts, transfer on death designations are contracts. We'll go into that. But I just find improper asset ownership is a lot of times a big pitfall. And then let's have an agreement to take a look at this, review this every so often, because things change, right? There was a study done that the average estate plan got reviewed about every 18 years, right? And so think about what was going on 18 years ago. It was 2005, how things have changed since then. And so this needs to be fluid to keep up with changes in your personal situation, changes in the law, and even changes in the different techniques. And so we'll show you our response to that, because most attorneys only charge hourly when it comes to after the plan is set up. We don't charge hourly. I'll show you how we charge and on that so that you can at least compare. And then you probably wouldn't be listening to me today if you didn't want to have some type of controlled transfer process when when you passed away. And so again, I'll be blunt. If you were to die today, how prepared is your family if something happened to you today? Right. And my follow-up questions are, would they know what to do, how to do it, and how to pay for it? And I just find it's a very reactive process. Typically what happens is there's a death that occurs and the family stumbles into the attorney's office at that point. They're in the grieving process and the attorney's charging hourly, one-on-one information. Things aren't sinking in. And people are like, why is this so expensive? Because the reactive process doesn't make any sense. And so what we thought was, why don't we empower the clients and, let them have control and know what their options are ahead of time so that they're not just beholden to the attorney. And so that's kind of where the idea is that we want to empower, the clients. And so to understand that, there's 5 ways you can plan out there that I see based on my experience. Is you can do no documents. We'll talk about that, and that's dangerous. You can do a will and a POA. And I'm sorry, I didn't do this. I didn't come up with this. Estate planning world, it seems like there's a lot of acronyms that are out there. And so most people know what a POA is, but it stands for a power of attorney. And a will is a legal document laying out your instructions, and it only of where your assets go, and it takes legal effect after you die. Okay, so a will doesn't give you any type of disability planning because it doesn't have any legal effect until you die. You have to give a death certificate for it to be valid, right? And so what happens is people will create what's called a power of attorney, and there's 2 flavors of powers of attorney. There's a financial power of attorney and a healthcare power of attorney. And go figure, financial power of attorney is a legal document designating an agent to make financial decisions for you. Within a financial power of attorney, there's 2 different subcategories or 2 flavors of that. There's what's called a general durable power of attorney, which is effective when you sign it. And then there's a limited power of attorney that's effective only after you become determined to be disabled. Some attorneys will call it a springing power of attorney. Do you see the difference between the 2? Okay. And then healthcare powers of attorneys just designate a healthcare agent to make decisions for you only when you can't communicate them to the doctor. And they've named these different things. In Virginia, it's called an advanced medical directive. A lot of states picked up on that. It's the same idea, is that you're designated someone to make healthcare decisions for you. It also has a component about laying out your constitutional right. It's called a living will component, and that people can kind of get that confused with the last will and testament. But a living will basically says, hey, if I have to be kept alive artificially on machines, I don't want heroic measures, and you can implement or put those instructions in. You don't have to, but those are one of the things. And so that's a basic plan. This plan, a will, and I'll talk about this later, will equals probate, which means if you have a will-based plan, then the family is going to go through probate on assets that you own. And that's just that approach. And that's typically a lower cost or investment up front, because you're just doing some documents and you're leaving all the work to be done at the end. Okay. And then the other is a will with a testamentary trust and power of attorney. A testamentary trust and power of attorney, kind of stay with me, a last will and testament. A testamentary trust is one that's created after death. And again, I don't know why people would do this. There's court oversight with that. And to me, not very limited circumstances where I'd see, yeah, that makes sense to me. Because if I could stay out of court with regard to these issues, I'm going to do it, because it costs more, it takes more time. Unless you want a judge to be an arbiter for your family, if there's some dispute that we need to, litigate. But that, to me, I find is very rare. I say this 4th option is a simple trust. it's a trust that you create during your lifetime rather than after death. I guess the term is not as simple. I mean, just people call them revocable trusts. But what's out there, a lot of people are in LegalZoom, they're selling these documents, but there's not really much counseling going on behind them. Yep, it's a trust, but don't know much more than that. If you have any of you who are on the Zoom today, have a trust, do you know what it does, right? So those are the questions, like, what does it do? What is it? So and is it funded? And I'll talk about funding. And I think the modern approach is more about, hey, we have a strong process in place to support the family on major life events if there's a disability and death, and we have the legal documents to support it, whatever they are, to get them to where they need to go, right? It's the process. Don't focus on these documents so much. I just think these are all bare bones planning in the middle here. No planning. I just think the modern approach is the best, but again, you got to pick what's right for your family. The challenges, typical challenges for estate plans: mental disability, by far, we're living longer. And so we just need to make sure that we've got those issues covered. Hopefully you never have to deal with that, but we'll talk about that. Asset transfer on death. How do we get assets to the next people in line as smoothly as possible? Taxation, minimize taxes, of course, to the greatest extent possible. And then personal planning goals, making sure that, you know, what you are trying to accomplish with the hard work you built up with, what you want to have happen. And we'll get into those. So those are the challenges. Those are your options, right? So, you know, which one's right for you? And remember I told you the idea with our approach is we want to empower, you know, you by giving you information, education, strong process, so that people know their roles, what to do, and get through this, deal with this issue. So it's a three-step approach. We want to empower the design by developing the plan with counseling-oriented planning partners. Let's sit down, let's go through your options and give you pros and cons of each. And if you have other advisors that you trust, like a financial advisor or the like, or tax advisor, let's hear from them too. It makes the plan stronger. The second step is empowering that legacy by maintaining the plan. Commit yourself and your family to a formal maintenance and education program. So let's make sure that we keep things on track. It doesn't have to be onerous, but there's certain things we got to check off each year, so that when something does happen, we can secure appropriate assistance to transfer your wisdom along with the rest of your wealth, which really empowers, you know, that inheritance and gives it a big boost. This is the modern approach, okay? And I think more attorneys are going this way. We've been doing this since 2007. So we have 15 years under our belt, and I'll show you what that means. But the traditional approach, and I still see it done today, is that the people will engage an attorney. Well, the attorney people will come to the office to see if they want to engage the attorney. The attorney will go through their situation, quote a fee to them, hold his breath or her breath, and if they say yes, go forward. Yep, we'll draft some documents, we'll sign them, and that's it. That's the end. It's usually 1 or 2, maybe 3 meetings, and that's the end of the process for all their wealth and their family. And so I just find, and then they think that document that they've done or is going to work if 18 years go by, right? or more before someone takes a look at it and their situation. And so I just think that approach is not, I learned early in my career that was not the way to do it as people were passing away. It's like this, you need to have some type of process and relationship so that it makes things go smoother, rather than you're just hopefully things are in place. And that avoids a lot of heartache, and it's much more efficient that way. So let me teach you some things about asset titling, and also if your only goal is to avoid probate, which I think, you know, that's one of your goals, but that shouldn't be your only goal. Let me teach you about that. So anything you own at death in your individual name equals a will equals probate. So I have a lot of engineer clients. That formula makes sense to them. Okay. And so hopefully it makes sense to you. But the idea behind that, if you want to avoid probate without any legal documents, you can do it this way. You can title all of your accounts as joint tenancy with right of survivorship. Okay. And So what does that mean? And so most people understand what a joint bank account is. When one joint tenant dies, by operation of law, you just bring the death certificate to the bank, the asset will go outright to the survivor. Okay. And so is that what we want to do? Well, it depends on the situation, right? And so this is not a one size fits all, but let's say we're in a married couple situation, right? And let's say Bill and Mary Sample, my favorite sample clients, and they've got 2 kids. And so let's say they titled everything as joint tenancy, Bill and Mary, right? So when Bill dies, I always knock off the husbands first. I'm sorry, that's just statistics. But when Bill dies, everything will go to Mary, right? By joint tenancy. There's no probate. Wow, so easy, right? Okay, so now that Mary is surviving spouse and potentially in the grieving process, now we want to saddle Mary or burden Mary with, okay, figure out how to title everything, because guess what? When you die, where is everything going to go? Going to go through probate because it's all in your individual name right now. So let's if we're going to do the planning, let's just do it right up front, so we don't have to burden the surviving spouse to figure all this stuff out afterwards, right? And so that's one thing. And then if you think just adding the kids on to the accounts or adding the next person in line on the accounts is the solution, think again. That's very dangerous, okay? When you are adding a joint tenant, an owner to your joint account, they're owners. They can do whatever they want with the money, and all their problems are your problems. So if they get sued, that money's fair game. If they get divorced, fair game. If they get in a car accident or something and they have creditors, right? So that is limited, and we have that's a piece of the puzzle, but that should not be a one size fits all point. And transfer on death accounts or payable on death accounts are the bank's contracts and forms, or the financial institutions forms. And I just think that you're just, again, it will get the assets to those people potentially, but you may have to be going through some red tape, and also you may be giving up some protection. So I'll explain that, but it does avoid it. And in some instances, we'll use the TOD designations if it makes sense. And then planning with the box is, I call the box the beneficiary designations that you have in your life insurance policy or your IRA or your 401k. That is doing estate planning when you designate those beneficiaries, and they just changed the rules on us. Okay. You're usually typically pretty good with the spouse being the beneficiary if you're in a married couple situation, but after that, all bets are off. And then it depends on your situation, what's going on. And so you need to know, hey, am I writing the right beneficiary designation on this? And so there's different options for that. And so that's dealing with it. So if you're just avoiding probate, you're missing that. What about your planning goals, right? So you're in a vacuum, and if you don't care about any of these things, this is just a sample list. There's more, but this covers a lot of the big issues. Then maybe that is the plan for you, right? So for me, these are some real issues that we find. Some are more important to people than others. We just kind of gauge your temperature on it. But the catastrophic illness, disability planning, remarriage protection, creditor protection, divorce protection, values promotion. So what are these goals? What does it mean? Why would I care about these things, right? So catastrophic illness protection basically means, that's the question is, if you were to have that big illness, right? Stroke, Alzheimer's, dementia, do you have an opinion if you'd want to be taken care of at a home or in a nursing home, or you don't care, right? And, my point to that is a lot of people think they've got their disability plan covered by saying, oh, I got a medical power of attorney or medical directive. And, those are a good start to your plan, but that's a document, okay? And that's a document that designates someone to make healthcare decisions for you and also decide where you're going to live. They can check you into a hospital. They can check you into a nursing home. They can keep you home and bring home care in, right? You decide, agent. My point is, if it's that important to you, where in your legal documents does it say what your wishes are, right? And if you don't care, then you're not doing your family any favors, because that's a big burden to them. My dad loved us, but he kept his estate planning real private. And when he got diagnosed with this disease called Lewy body disease that caused dementia, we were guessing. and we didn't know what he wanted. But I'm guessing he wouldn't want to burden my mom as long as it went on for, because it wasn't a 2-year illness, it was 10 years. Okay, it got gradually worse, but towards the end, it could have been a lot better if we had talked about things. And so I think my point is, is that I know it's a tough discussion, but I think the attorney's role is to, lay out some instructions. And I don't give you a blank piece of paper and say, give me your instructions. We have checklists and the like that help facilitate the discussion. And I do think a discussion goes a lot further than any legal document we can create, but why don't we create the best legal document and have the discussion, right? And support it is what I want for my clients. And so that's important, the disability side of it. I really want to make sure that's as smooth and we make sure we get those things covered. And then, other things is having the access to resources that you may need. And another big issue with disability planning is not just the healthcare decisions, but is there a point in time when you should not be writing the checks anymore? You're right. People are taking advantage of you, right? And the money is going out of the estate that you worked hard for. And so a lot of the legal documents I see out there say when two doctors anywhere in the world say I'm disabled, that's very generic definition. It's not easy to address that because you don't just wake up one day and have Alzheimer's, right, or dementia. And so the way we approach that issue, to give you kind of an idea of the planning, is there's 3 critical questions I see when it comes to disability planning with regard to your assets is, when am I disabled? Okay, and be very clear on that. And as you define it, and then who do I trust managing my assets if I ever do become disabled, and what can they use the money for? When, who, what? And so, yes, you need a doctor as part of that when, but maybe we have, if you're married, maybe my doctor and my spouse when they agree, or when my doctor, spouse, and a second medical opinion, or spouse and a family friend, or kids, right? So we build a panel of, hey, here are the people that if we were sitting around a table, they have one question to answer is when can I effectively manage my financial affairs, right? They're not making healthcare decisions. They're just trying to decide, hey, is dad sending checks to the wrong place? And my dad got taken advantage of too. And that's kind of where this came from. And then who do I trust managing the money? And so the who made the money, I trust put assets here. I don't want to go through court. I don't want to go through any type of court proceeding. This is who I trust for the money, and this is how I want the money to be used. And again, we've got checklists to lay out those instructions. This is beyond the scope of today, is this catastrophic illness planning is if you have a long-term care illness and in the Washington metropolitan area, if you need to go into a nursing home or you need long-term care, it is astronomical as far as the expenses for long-term care. It's anywhere from I've seen $6,000 to $7,000 a month to $20,000 to $30,000 a month for long-term care expenses. Okay, and so that blows through people's retirement, and there is a way through the use of trust to protect against that. But that's for extreme examples, and so it's Medicaid. There's Medicaid would be involved there, but you have to basically be penniless. But I just want to let you know that is out there. Okay, and that's enough on disability planning. Remarriage protection, I don't spend too much time on it, but like I told you, my classic married couple, let's say Bill and Mary sample, they have 2 kids, and let's say they have what's called I love you wills. Very common. I love you will says when Bill dies, everything goes to Mary. When Mary passes away, everything goes to the kids. If Mary were to predecease Bill, it goes the other way, right? Very common. So let's play this out in the remarriage context. So Bill dies. I remember I have Bill always die first. Leaves everything to Mary. And let's say Mary meets Bo, the tennis pro, right? And they fall in love and they get remarried. And let's say Mary predeceases, Bo, but her will says everything goes down to my kids. Even though her will says everything goes down to the kids, does the new spouse, Bo, does he have a right to those assets? Absolutely, right? In all 50 states, they have this spousal right. They want to protect the spouse. It could be anywhere from a third of the estate, a fourth of the estate, sometimes even a half of the estate, depending on the length of marriage, okay? and the number of kids that you have. And so that kind of, whether that's important to you or not, that might be an issue. And another important point is that, if you are taking notes, is that title will trump the legal documents. And this is where it comes down to this improper titling of assets, is that, remember we talked about joint accounts. Most married couples own their assets as joint accounts. So if Mary and Bo, right, the new spouse, had things titled jointly, when Mary dies, everything goes to Bo by operation of law. It does not go through her will. If who's usually the beneficiary of an IRA in a married couple situation, right? Spouse. So if Bo was the beneficiary, the custodian of the IRA does not care that the will says everything goes to the kids. They're going to give the money to Bo. All right. So if there's a way that Bill could leave all of his assets to Mary, she could use it for whatever she wanted, but if she got, when she passed away, it had to go down to the kids. Is that something that was worth spending some time talking about, right? Is that counseling? Is that word processing? And so you get an idea that we're trying to get through and get to know what your answers are, not just something off of a computer saying, oh, put this answer in. The third one is creditor protection. Creditor protection, I think this is an important one to kind of talk about. So I have a story for this one. So I tell dumb stories to get points across, but I like this story. This is my school bus story. So let me tell you, in my school bus story, there is two assumptions, we'll say. Let's say I'm dead in the story and there's no creditor protection for me while I'm alive. And so let's say when I die, there's a couple different, let's say when I die, my spouse is all distraught after I passed away, driving on the road, kind of like the other day in the Northern Virginia area. It was a little bit slick out there. It was a little rainy. She runs a red light, bam, hits a school bus full of kids. Let's say horrible facts. Let's say one of the kids dies. She hates herself. The world's against her. I don't have enough insurance or money in my estate to pay for this, right? These are catastrophic credit. So there's a couple different ways I could leave my assets to my loved ones. I'm going to show you that, and a different impact or result based off of these creditor issues, right? So the first way is I could have left my done a simple will, left everything to my spouse. She receives it after I die, all outright in her name. She hits the school bus. All those assets I left to her are gone. Okay, that's option one. Option two, we could have titled everything jointly. And when I die, everything will go outright to her. But now the creditors, right? They can put the lien on the house. Sure, it's in her name. Can they do a bank garnishment? Sure, they can do all of those things. They can take any assets that were jointly held. Those are all gone. Third is by contract. Let's say I have a life insurance policy that's not worth a lot when I'm alive, but I write my spouse's name as the beneficiary. She gets a check, let's say for $1 million. She puts that $1 million into her account. She hits a school bus, that $1 million is gone. Okay. The fourth way is I could have done one of those simple trusts. I call them bare bones trusts that said, hey, when I die, everything goes outright to you. Same problem. Okay. So let me do my planning again. Let me pull myself out of the grave, do my planning again. Let me do it this way. Let's say I did this. I could leave my assets to my loved ones. They could use it for whatever they wanted. But if they hit the school bus, it's protected from their later creditors. So let me say that one again. That's a big one. I can leave it to them. They can use it for what they want. But if they have creditors or they hit the school bus, it's protected from their later creditors. So I want you to connect the dots here. Okay. So remember that definition of estate planning I gave you before. I want to control my property while I'm alive and well, plan for disability. This is the part where I can give what I want to whom I want, when I want, in the way that I want. All right. So how many of you would like to leave your assets to your loved ones that way, protected from their later creditors? So, and how many of you have been asked that question before? Is that counseling? Is that word processing? And so it's just a basic understanding of trust law. And I think it's very powerful when you think about it. It depends on your situation, right? And most people like it. But, again, my job is to bring up the options. So think of a revocable trust. Okay, think of people get confused. A revocable trust, what you know about revocable means you can change it at any time. Okay, you can amend it, change it, and that is a good part to any good estate plan. But from an asset protection or creditor protection point of view, think of a revocable trust as like an open bucket, or my open Yeti here. You can get in and out of it, use it for whatever you want, but your creditors can as well. Okay. So don't leave here thinking, oh, I got a trust. I'm going to get a trust. I'm going to get protected for everything. Your revocable trust doesn't protect you against any creditors. Okay. It's a great tool to centralize management of the assets, plan for disability, lay out things. But when you pass away, you can say, this is my hard-earned wealth for my beneficiaries. They can use it for what they want. It's not for their ex-spouses. It's not for their creditors. With those people can take, use their money, but with my money that I'm leaving to them, I'm using it and giving them the key to it. Okay. Very important concept in trust law. And, creditors come in different forms. And so, I said school bus, but I think a bigger and bigger deal these days is one creditor is Medicaid, or if you have a long-term care illness. Okay. Remember, I told you have to be basically penniless before you'll get any assistance for long-term care. Anything in these types of trusts, they're off the radar screen for that. That's very powerful. And I just find that the beneficiaries are getting older, like the kids are, 40 and 50 years old. And so they like these things, but they don't know that, they can't do it for themselves. It's their parents that have to do it. So again, these are just options and issues to look at when you go there. And divorce protection is straightforward. How would you like to assure that the assets you leave to your beneficiaries stays with them, right? Rather than go with any new outlaws that I call out there. So that's that one. And then values promotion is this, right? This is that non-material wealth. If there's an opportunity, I use my babysitter story for this one, the babysitter story. So I have a 7-year-old, and so when we were trying to hire our first babysitter, we were giving all these instructions to the babysitter. We were trying to go out for one night for a relaxing evening for a dinner and a show, right? But we're giving all these instructions. She's going to want to stay up late. If you read a story to her, read every page, because if you skip a page, she knows. I don't know. She won't want to brush her teeth. Make sure she doesn't play, watch TV or anything like that. We're going to be at this place. Our neighbor's information is here. You get the idea. Lots of instructions, and we're just going away for one evening. So my point is simple. Would you agree we leave more instructions for our loved ones when they're little and we're going away for just one evening for a dinner show than we even think about leaving in our estate plans when we're going away for a lifetime? And again, it's not something where I'll give you a blank piece of paper. If there's places where we can identify, record, and memorialize some of these values or life lessons, we'll point them out to you. Okay, so those are the things that we see are important. And I think the counseling process is really kind of like the trip to the eye doctor, where we'll narrow it down. Do you like this one or this one better, one or two? Even though I'm always guessing when I go there. But the idea is we'll get it narrowed down for you. So that's kind of the idea with regard to counseling. I was kind of give you a flavor of how we do it, because that's the most important. Once we know that, everything else will flow nicely. Okay, so then we maintain the plan. Okay, so what does that entail? Early on in my career, I would focus on, hey, things change a lot and you need to maintain it because things change. And I think people get that. I just think people now, they just don't want to pay the attorney hourly, because attorneys only have hourly billing. So it's like, okay, focus on the fees and what you're covering, and then, let them decide. So it's optional, but we have a maintenance plan. We think it makes sense. So we charge $995 a year for our maintenance plan. So if you were looking at fees, that's one of our fees, optional. And what do you get for that? Well, I'm not going to nickel and dime you for phone calls, emails, faxes, even though no one faxes anymore, letters, copies, word processing amendments. The idea with regard to that is, if you have an issue, I want you not to be worried about it. I want you to call us and we'll address that issue. Okay. The big one, I think, is annual funding double check and ongoing funding support. So that's another one where I didn't come up with this term funding, okay? But you need to understand this term funding when it comes to estate planning. If you're going to do a trust, okay? And so I apologize, but I want to make sure you know what funding means in the estate planning world, okay? So that annual funding double check and ongoing funding support, I think that in alone in itself is worth the $995. But let me explain how it works. So when you create a trust, the common pitfall that I see in most trusts that I see out there, the first question I'll ask is the client is it fully funded? And if they don't have a blank stare saying, what does that mean? And then they'll usually, funding basically means, did you put everything into the trust that needed to go into the trust? And the reason why, okay, almost everything should go into the trust, okay? There's certain big exceptions like a retirement plan, but basically most people partially put their stuff in there or don't put anything in there. Why is that a problem? So you spend all this money on this trust, the trust doesn't work unless you fill up the tank. And that means retitling bank accounts. It means re-registering your non-IRA investment accounts. It means retitling real estate. It's a pain. It's tedious, okay? But the benefits are big, okay? Because once everything is in there, it's all centralized here. It's easier to pass on, right, to the next generation, next person in the line. And so if it's not titled, what happens is, and I'll give you some legal technical here, most of these trust packages come out with, yep, we'll give you a trust and what's called a pour over will. Pour over will sounds nice, okay? I call it the legal pooper scooper, cleans up after your mess, okay? It says, if I forgot to put something in my trust during my lifetime when I should have, scoop it up and pour it into the trust after death. Well, that sounds great, right? The problem with that is you got to go through probate on all of those assets before it gets into the trust. And then you got to do a trust administration. And I didn't even get into that, which we will get into. I'll tell you the basics of that. But you got two administrations. You would have been better off not even doing the trust, okay? Because the follow-up is really critical. And if it's all titled right, then it does not go through probate, okay? So we avoid the court process. There's still work to be done. I'll explain it, but we're not on the court schedule. We keep everything private. And it's all paperwork that we're pushing back and forth between different financial institutions. This report is our report that we provide to our clients each year to say, here's your scorecard. A check mark means we've got it verified, a piece of paper in our file that account is in your revocable living trust, RLT. Sorry for these acronyms and the like, but you would learn all that. And every year, give us the new values, okay? So that we don't, and then if you bought something new, there's a place to add it. If you sold something, cross it out. The purpose is we don't have to play Sherlock Holmes to go find everything when something happens to you. I hit a button, I know exactly where everything is at. It cuts a tremendous amount of time and expense off the administration. How do I know? I've done over 50 administrations, okay? And so that's one that puts us miles ahead of most other firms. Like, how could they not have something like this? And we update it on an annual basis. The other thing is, if your assets are dwindling, that's red flags for us to figure out, is there a disability? Is someone taking advantage? So these are different issues to be thinking about. Or if the assets are on the other side going up, hey, you may have a tax issue. Let's think about, you might think about some other strategies here for that. So that's the asset review report. That's what I mean by annual funding double check. And oh, by the way, I don't believe that you're never going to do any other transactions again. So if you open up another investment account or get into a real estate deal or something, we'll help you get that title right from the get-go, right? Makes sense. So that's and all of this stuff is coming from the idea that we're going to be there to do the administration. And we want the plan to be in the best possible shape for your family at that time, okay? The family meeting is no additional charge as long as it's done within 6 months of you signing your plan. Obviously, you can do additional meetings after that, but it's an optional meeting. And I just find that getting everyone on the same page, level of transparency is up to you. Every family has different dynamics, but knowing what their roles, responsibilities, and the like, whoever the backups are. Every year we have an annual group client meeting, okay? So I leverage a lot of economies of scale and get a lot of information out to my client base. Now through Zoom, we're very easily, like here in January and December, we do our annual client meetings. We have a couple of different Zoom meetings and I go over what the laws were. The biggest one that impacted most of my clients was Secure Act 2.0 was passed in December of last year. And the regulations are all working their way through now. And so I talked about it then. I'm going to do a special program for our clients on, hey, here's your beneficiary designation options now that we're in Secure Act 2.0, right? And let's make sure that these beneficiary designations that you've got, we look through our clients' files and say, hey, maybe this IRA, maybe we need to change the beneficiary designations on these IRAs given the new laws, okay? And so that is huge. And we would work, if you have a financial advisor, working with your financial advisor to make sure we're on the same page with them as well. And then every 3 years, we'll actually update your legal documents. And we do that in group format too, okay? We have a way of doing this very, we've done it for 15 years. And basically, we have a report that we send you. And the report is just an executive summary of your plan. And it's a way for you to give me quickly any changes to the key players, your trustees, your disability panel, your beneficiaries, your medical agent, your financial power of attorney. So you can give us very quickly changes to your personal situation, and we'll put the legal updates in, and we can sign. We have, a way to sign, do updates, and leverage it where we have people coming in and just signing the documents after we've educated them in the group format. So plans are stay fresh, okay? Because if your plan is 18 years old, completely new tax laws, and all the tax cuts that are in place now from the 2017 Tax Cuts Jobs Act, they expire on January 1 of 2026 because Trump didn't have the votes to make them permanent, okay? It went right down party lines, which means it's a budget reconciliation, it's got a sunset, and now we're back to the old tax laws unless they do something. And I ain't counting on them to do anything, so I don't know. So we'll see what happens. And then the group educational programs on different topics that are important. The one that's kind of the most important one that we have clients that's required, we call it our clients call it the 911 program. But it's basically a program that goes over what you need to do when a loved one becomes disabled or pass away, like the first 4 things that you are not, this is our website client dashboard. The client's advisory board said, put it in big box so that they know they have to go look at that. And it's just a video I go over. And if you have minor kids, there's a one for guardians and trustees of minors, but what to do when a loved one passes or becomes disabled. That is something to give you some basic information so you know how that works and the main things that you need to do at that time. And then DocuBank membership. Okay, so DocuBank is like having your medical directives online. And so remember, your medical directive is a document designating your healthcare agent if you can't make healthcare decisions for you. But if you get into an accident, you're probably not carrying that medical directive in your back pocket. But our clients are. So you'll get a little credit card. And the idea with this credit card, can't charge stuff on it, but it'll keep your medical directive stored. And I tell my clients, sandwich that card between your driver's license and your health insurance card, because if you go to the hospital or they're going to want to know, or medical care provider, they're going to want to know who you are and if you can pay. And this says my medical directives are here. You can call a phone number, it gets faxed or emailed 24 hours a day, 365 days a year, or your healthcare agent can just pull it off the web and send it to them. I'll show you how quickly I can pull it. So there's a member number and PIN number. You go on there, and you'd be trained on how to do it. But literally within 20 seconds, I'm going to have my legal documents laid out there. And so you don't have to go scrambling for where the medical directive, or we got to sign a new directive that the hospital is forcing down on us. No, I did this directive when I was in calm circumstances, and I know who my agents are and I know my wishes at that time. Okay, I don't want to make any last second changes on it. You can if you want to. Also, some other benefits. These are not legal benefits, but this is something that would have been nice for my situation with my dad. As he had those illnesses, he had a bunch of medications that he was on. And so there's you can have it all in one place, the dosages and the medications, so that people aren't trying to guess what you're doing. And then a medical history is always helpful for the doctors and the healthcare provider. So your primary, any conditions, any history of vaccinations and the like, you can put those in there. They're not required, but this is just to help make the plan work stronger, okay? So it's not just about those legal documents. So I'll try to paint the picture of the maintenance plan. Also, the last thing is, Think about all your online accounts now. So, this asset report has all your physical assets, but what about all your digital assets? What about your email account? What about your Apple or Amazon account, photos, music, website, domains, all that stuff? And so we don't want your usernames and passwords. We just want to know, do these things get shut down or transferred to the next person in line? Okay. And think about how many of those you have. And so, we have a service that's part of the deal to make that as smooth as possible. Okay. So that's $9.95. There's a setup fee in the first year to get on the maintenance plan so that we can get you enrolled with DocuBank and enrolled in the digital executive services and make sure we get your portal set up and everything. So we charge $1,500 in year one to get you set up on the maintenance, and then it's $9.95 a year. Okay. And we will get into fees. I think we're close to fees now, so don't worry on that one. So that's my maintenance plan in a nutshell. Okay. And these are just kind of showing us all this kind of a review of these are all the things that we're doing for that. So these are the things going on in the background. Hey, we're making sure the assets, we got your assets on we know your latest instructions. We're giving you the update on the education and the like, and we'll and so those are the maintenance plan benefits and what we do. The third step, right, is this is when the rubber hits the road. So we maintain it now, secure appropriate assistance to transfer your wisdom along with the rest of your wealth, right? We want to make sure that administration is as smooth as possible. So what do we want to look at there? So I think when we find appropriate assistance to transfer our wealth, then I think part of that is, okay, what about, I'm thinking about costs now. So, how can we control the costs in the estate planning world? And this, we want to get full disclosure of the costs so that we have true peace of mind on, okay, my family's not just going to go into the attorney's office and there's no idea what the costs are. We have it all laid out. All right. So how to control costs. I've already mentioned this in the estate planning world is full funding, right? Full funding is the process of putting all of I have a little visual for this, so I'll go through it real quick. Full funding is a process of putting all of your assets into your trust. I love that one. so that's why does that control your costs? It controls your costs because I'm not going through court, or you're not going through court to deal with that, and we have to account for every penny to the court on that and fill out all their forms with regard to that, which cuts a tremendous time and expense off of that. So full funding reduces the cost of the plan. Okay, proactive trustee and beneficiary training. Rather than doing the education one-on-one in the attorney's office during the grieving process hourly, why don't we do some of the education in advance in a group setting to keep the cost down, right? Radical concept. So that's the idea, the proactive training, so that you know what to do at the appropriate time. You're not moving things in the wrong place and making the plan even worse, hurting the plan rather than helping the plan. And then we have a proactive engagement approach where if you're on our maintenance plan, we'll agree to do the administration at predetermined rates, okay? But we can't lock your family into hiring us. We don't want to. The successors have to hire us, okay? A lot of our clients want us to lock their family into it, but I can't ethically bind them, okay? But we know that we'll honor our rate, and it's below market rates. I'll show you the market rates because we know where everything's at. We've got a plan in place. We're ready to go, okay? And so these things, I think, control costs. So now let's talk about the full disclosure of the cost. So every estate plan has 3 sets of fees. The cost of the setup, and that's where most people know, cost of initial counseling and documents. That's where most people focus on, okay? But then they don't focus on the cost of updating or failing to update their plan or the cost after death. They don't really focus on that. So I'm going to show you all 3, okay? And I'm going to focus I'm going to begin with the end in mind. I'm a big Stephen Covey fan, if you know him. But he, so let's look at the cost that no one looks at, the cost after death. And so, yes, I'm an estate planning attorney. I am a nerd. So the idea is as follows. So this is this is a Virginia one. I have a Maryland and a Florida one I'll show you, but just give you an idea. This is to give you an idea of how estate fees are charged after death when someone passes away. And if you have a will, Commissioner of Accounts is basically if you go through probate, these are the fees that the Commissioner of Accounts will approve or reject, but these are the guidelines. They say, and I love how it's in quotes, the Virginia Code allows reasonable compensation to fiduciaries. So, and so this is what usually happens is, in a married couple situation, spouse is the executor, wife is the executor, if the husband passes away first, or spouse is executor, and then they don't know what to do. They hire an attorney. The attorneys will charge in these ranges. Okay. Do all attorneys will charge this? No. Some will charge less. Some will charge more. Depends on how out of whack the estate is. But these, if you stay within these guidelines, right, then you've got that's the fees that they've been statutorily authorized. So you just got to give a good reason if you go over. I don't find people go over unless it's really, there's some unique things, and I'll show you that. But it's off of a percentage of the estate. And a lot of people don't like these percentages because they're pretty high. And so these are, while the assets are tied up in probate, 5% of the income receipts. So income is like rents. If you have dividend income, interest income, 5% of that every year, boom, that's reasonable. And then if you have $1 million worth of assets, they based it off 5% off the first 400,000, 4% of the next 300,000. So you see, it's off of a graduated scale, okay, over 1 million, 2%. And they even put in here, they say, look, the commissioner can increase or decrease the compensation in exceptional circumstances. So it really just depends on the nature of the assets, character of the work, and the like, okay. Loudoun is the same as Fairfax County, Maryland. Montgomery County, Maryland. Maryland is basically 3.6%. Attorneys can charge. They let them charge 9% up to the first 20,000, and then anything over that is 3.6% of the assets that are going through probate. Okay. Fees after death. And now I put Florida statutes in here. Why do I put Florida in here? I don't put it in here because I'm talking to Florida people, although a lot of clients seem to be moving to Florida. The reason why is Florida. Would you agree Florida has a strong like senior lobby, right? Senior contingent. Some people call it God's waiting room. And so you just drive into Florida, there's a living trust billboard. So they know trust very well in Florida, okay? And paragraph 3 is what they finally passed a law that caps what an attorney can charge to do a trust administration. So I just talked to you about wills and probate, but you might be thinking, why is there a trust administration? So this is an important point. So there's 2 teaching points for putting up this Florida statute. The first teaching point is when you die, whether you have a will or a trust, death is a major life event. All of your affairs have to be wrapped up, okay? Like I said, think about how many online accounts, everything has to have closure on that, okay? So assets don't just get magically transferred to people and with no time, no delay, not even the advisor or the banks knowing about it, right? We got to deal with every aspect, every financial institution, every financial relationship, every legal, taxes, IRS, right? All of that got to be squared away and wrapped up. So it's just that we're not on the court schedule and not having to deal with a court with that when we have everything properly in the trust. So that's number 1. The second teaching point, because Florida has such a strong senior lobby, this paragraph 3 basically is boiled down and says, look, if you're doing a trust administration, you get a 25% discount. You could charge 75% of what you could have charged on a normal probate, and that's reasonable for attorneys. And because Florida is such a strong consumer protection state, I kind of use that to say, Virginia doesn't have this or the local jurisdictions, but this gives you an idea of what trust administration is going for. It's not a public record, but if you have CPA buddies, it is a deduction on the tax return, and you can ask them what attorneys are charging. But this is Florida's probate schedules, which are lower than Virginia and Maryland, go figure. But they're still percentages, right? 3%, 100 to 900,000, 2.5%, 1 to 3 million. Okay, and you get 25% discounted. Probably more than you ever wanted to know about that, but I needed to give you background on that. So that here's how we set our fees. And these are ranges. I don't know exactly what we would charge you until we know your specific situation, and you're not going to pay anything until we know exactly what we would do, a specific fee quote, scope of services. But this gives you an idea. So I just talked about, gosh, my cursor is all right. So I just talked about settlement and administration. So I'll go through there. So we have two options as far as how we set our fees. So I'll start with our settlement and administration options. This is after death, and it's only if we're hired. So it's not mandatory. It's only if we're hired. Everyone does hire us. All of our clients do, but you don't have to. We would agree to cap the administration fee at 1.25% on the size of your net estate. And so you just saw 5%, 4%, 3%, 2%. We're going to be well below that because of the maintenance plan. Okay. And the reason why is that if I have a fully funded trust and I'm not going through probate, that makes my job easier. That translates into a cost savings. If I have an educated family that didn't move things in the wrong place, followed the process, knew what to do at the appropriate time, makes my job easier, translates into a cost savings for you. If I have a financial advisor where our back offices are in sync and we're able to set up the inherited accounts, great, right? So that's where that maintenance plan is the key. And I already told you, that's the fee for the maintenance plan. And that reduces the back end. The cost for setting up the plan under option one, we charge 0.5% on the size of your net estate. And that's a minimum. Our minimum fee is $4,000. Our maximum fee is $13,500. Where you land depends on your goals, your assets, and the like. If that's too high for you, the lower fee option is 1/3. Our maximum, still our minimum is $4,000. Our maximum there is $10K. The difference is we're going to charge the for the settlement and administration, we'll charge a higher number, 2%, if we're hired on that. Okay, I don't care which option you take as long as you understand your options and compare apples to apples. This is not just setting up the documents and selling documents if you're looking at LegalZoom, right? This is setting up the plan and making sure we counsel you on the options and then putting everything in the plan, the trust, okay? And so that's a big deal. It's the funding or the titling and re-registering, okay? And so make sure you compare apples to apples, because if you typically you just get the documents, here, you do it. That doesn't happen. And that's where all the expenses go. That's how we set our fees. There's two questions people ask me. You probably, you may wait till the end or not thinking of it. What if something happens to you, Bobby? I have more people worried about my health and welfare than I've ever had in my life. I would not be a good attorney if I didn't have a good succession plan in place, right? So, like I said, we have a team of 10. I'm developing. The associate attorneys still have some time before I feel comfortable with them as far as becoming, they have a path to becoming partners, but there's still, some time there. And so for that succession plan, but then until that time, I have an external arrangement, and Ed Clay, his bio was in your packet, should be. And he's my backup attorney, and he teaches with me at the National Network of Estate Planning Attorneys. He's agreed to take over my clients if I get hit by the bus, and I've agreed to take over his. And our structure, this is how we make, our money. This is our business model, basically, it supports it because the maintenance and education, we have residuals coming from there that reduces the stress for the attorneys, and our team members know they have a position. So the team stays in place, and the new attorney comes in if something happens to me. And the settlements and administration, all of our clients administer with us. They don't have to, but it shows it's very predictable. And the upfront cost of the counseling and design, we're not getting more cash flow. It's just we have less clients. I see some of the things out there. I call them will mills, where they're trying to create hundreds or thousands of plans in a year. Our goal is to create 60 plans, okay, and do a really good job on those 60 plans. And less clients, better relationships, better plan. And then the second question people ask me is that $995 going to go up? It will at some point. It went up 2 years ago. It had not gone up. No, it's actually going up next year, but this is the fee that it's going to be for our charter clients. They had a $50 increase. Okay. So it's not $75 increase. So it's not something where we're going to increase it. And that was an increase from 7 years ago. So it's not like we're increasing it every year. We're keeping up with inflation making sure we can, and if this is actually a loss leader for us, the maintenance plan, because think about it, we're reviewing the files each year, going back to them, making sure everything is in good shape, versus other attorneys are just going finding next client because they don't deal with that, right? And so, but it really has been a real boon for us because the plans run smoother, the settlements are smoother, and go figure, our clients are referring us other people, and so that's actually better. And so we should probably be tracking that side of it. And so to me, it just makes sense being proactive on all of that. And that's how we charge and work with clients. And again, nothing gets charged until we know your situation and what we're trying to do. But if you're talking to attorneys, right, on fees, I'm probably dating myself. If you know who Paul Harvey is, he was a radio announcer, and he would always say, what's the rest of the story, right? And so I would say, what are the rest of the fees the estate planning attorney? So yeah, this is what you're going to charge me for the documents. How much are you going to charge me to fund it? All the assets, right? And then what about trust settlement administration? What are you going to charge my family when I die? If they say they can't tell you that, say, well, here are my assets. I die tomorrow. What would you charge my family, right? Probably not going to like the answer that you see on that one. And then death tax return preparation. We didn't talk too much about death taxes, but the idea of death taxes is that we have a very high exemption right now. Okay, you can die with basically up to $13 million, and there's not going to be any federal estate tax due per person. Okay, if you live in one of the great states like Maryland or DC, Maryland says we don't care what the feds say. There's a $5 million coupon, and so anything over 5 million is subject to estate tax. And then DC just lowered theirs to 4 million. So the state estate taxes are at a 16% tax, and then the federal is at 40. These laws are always changing, and they're going to change. They're going to be cut in half on January 1 of 2026 on the federal level, just by virtue of all those tax cuts expiring. That still may not be, you still may not be over $6 million at that time, or $7 million. But there are some things that you do on the estate tax side that it might make sense to do some death tax returns to preserve or protect assets down the line. And then probate services, you know, this is a trick question. I would say, how many of your trust-based plans wind up being probated? So we've had one out of our 50, not a full probate, just a smaller probate, but that was on a foreign asset that was not disclosed to us. Okay, so who's that on? It's not on me. Shouldn't be, but we tried to do that. So that's the idea with that, is that we are not going through probate on a regular basis. I was frustrated by that one because probate's just such a, to me, it's just a time waste, but that's it. And so the cost after death, if you look at all those different schedules, if you do probate, those are those probate fee schedules, right? 2.5% to 5% I showed you. The standard living trust planning, I showed you those Florida schedules where you get a little bit of a discount. And our planning process, we've done a review of them, is usually 1% to 2% for the entire life of the plan. I'm not promoting this on, you know, price, but this is one of those things that if you look at the whole picture, it makes sense and is best in the end. Hopefully that gives you true peace of mind, but that's how we do it. I'm coming towards the end here, so I guess it is about an hour and 15 minutes, depending on the question. So, and so the traditional planning versus the modern approach. The traditional planning is, you know, you get your basic documents and questions answered, and that might be where you're at in life. But the modern approach is so much more just seeing what happens, you know, after the people pass away and the issues. It's the counseling, it's the funding, it's the maintenance, it's the updates, education, right? It's all those things that are there. And so I'll wrap up by just checking back in with my sheet here to see if I've covered all of the issues that I wanted to cover, all the questions. So these are why I'm asking these questions, right? I would ask the attorney, tell me about your background and experience in the planning field. What percentage of your practice is in estate planning? So I told you 60 to 70 is estate planning. This is what we do. We don't do family law, personal injury. We do business law too, though. How do you define estate planning? That's our definition, right? Control while healthy, plan for disability, give what I have to whom I want, when I want, the way I want, all while assuring my wisdom is transferred along with the rest of my wealth. What's your counseling philosophy? That's that pyramid where we want to get to know the family layout first before we get strategies in place. Our counseling philosophy is I talked about that. What's your process for working with me? I forgot to go through my process chart. So I just find process produces predictable results. And so you are, I hate that. Hold on. Let me, sometimes my PDF gets, has some problems, but here we go. So you're at the Truth About Estate Planning. I call it the experience. That's with me, no charge, about an hour to an hour and a half. The next meeting is no charge. If you're interested in exploring further, it would be a discovery meeting with either associate or paralegals or associate attorneys. And they're going to go through your personal information form, go through a goal exercise with you, give you some homework, answer any questions that you have, and give you an idea of the fees, a tighter fee range on that. The initial interview is no charge. That's typically with me. There are specific fee quote, scope of services, engagement letters, make sure you're comfortable with everything, and that's a good fit for both of us. And if we both decide to engage, then we just do the design of your plan. Remember that trip to the eye doctor? We'll go through all the issues. I think that's an important one. You know, that's between anywhere from 2 to 4 hours, depending on your situation. I would never keep you in a room for 4 hours. I would break it up, right? But I think that's the important part, is making sure that we get your instructions laid out so that we deliver and review meeting. I stopped calling it the execution meeting. But the idea with that is bad joke, I know. We go through, review the legal documents, make sure you understand them, answer any questions that you have, and sign, witness, formalize, make everything legal. And then we're not done, right? So now let's make the plan work. Let's put the fuel in the tank. So we do a financial strategy meeting. This is a dedicated meeting where I'll go over and if your financial advisor wants to attend, they can attend any meeting. But that's one really highlighted where we want to make sure the estate plan is coordinated with your financial plan. We want to make sure we have an accurate inventory of your assets. And like I said, with that report, we're just going to go through each asset and make recommendations. Hey, this is how it came to us. Here's how we recommend the titling based off of your goals. Does everyone agree? Once everyone says, yep, this is a good plan, then we manage the funding process, okay? I've got 2 funding coordinators. It's that important to us. Ginny or Taylor would be running that funding meeting to make sure that everything gets put into the trust, okay? All the magic forms that you need. And then optional family meeting. I'm not going to force it on you. Not yet, but the idea is no additional charge as part of the plan, just to make sure, level of detail is up to you. They know what to do at the appropriate time. And then you're just on maintenance, okay? People ask me, how long does the process take? I mean, you'll have your documents in your hand if you're motivated within 6 to 8 weeks. The funding process takes a little bit longer, okay? But that's because we're waiting for things to come back from the financial institutions, the court, and the like, okay? But the plan is in place at that point in time. So that's our process. We know it works. I'm very comfortable with that. How will you counsel with me to design my plan? So the way I talked to you today, it doesn't get any better than that. I'll tell stories, give you visuals, and make sure that we're talking. I'm trying to be clearer to you. Okay. Sometimes I get accused of talking too fast. Just let me know. Tell me to slow down. This is an important one. I would ask the attorney, how do we assure that my assets are controlled by my instructions contained in my planning documents, right? Who's responsible for this coordination, you or me? That's a big one. We're doing that here, okay? That's a big deal. How do we assure? Now, there is some limitations. So I shouldn't say, if you have 20 properties, we're going to talk, okay? And we're going to have to make some special provisions, right? So these are just standard guidelines with our clients. But once I know your situation, we'll say, oh, okay, well, they've got an asset in Wyoming or something. Well, we got to make special plans for that. But this is the basic idea and the basic range of the fees. How do we assure that my plans stays current with changes in the law? That's our maintenance plan. What's the level of involvement of my family in the planning process? I recommend more is better, but every family is different. How do you charge for services? Specifically, how much will my estate be charged after I'm gone, right? What if I'm disabled? So our disability process is very strong so that we're not going through court, not getting tied up. We have that, it's basically refunding or retitling your assets, okay? And so we have a specific process for that. And if they're a living trust attorney, a trust attorney, right? I would ask them, what's your record with regard to probate? We're 50 and 1. What percentage of your trust-based plans wind up having assets probated? Do you charge differently for those assets, right? So ask the right questions. Do you handle the filing of the death tax returns if they're necessary, right? That's that issue. And if you're anywhere close to 5 or 6 million, you might need to do it to protect some of that exemption, okay? That's a judgment call, but someone's got to be looking at that. That's part of our deal. That's part of our administration fee. What happens if something happens to you? Their succession plan, right? I showed you ours. How do I prepare for our consultation? Just complete the personal information form and show up to the discovery dialogue meeting. And we usually do those through Zoom. If you want to come in, you're welcome to come in. What type of service should I expect from you? We're a big believer on team approach. We've got, you're going to get much more value. We've got, me as an attorney. We've got Wendy as an attorney and a settlement coordinator. We've got a funding coordinator. Michelle's great at the scheduling and keeping the client events in line. So better by having a team approach rather than have 1 or 2 people try to do everything, right? Do you expect any commitments from me? Just fill out your personal information form, respect our time, our process. These are things you should be thinking about regardless of who you go with on the estate planning side. Is think about your planning goals. I'm hoping today I got you thinking about some stuff. What issues are more important? Is it the disability planning? Is it the creditor protection? Is it the divorce protection? Is it, those types of things? Who will fulfill the necessary helper roles? Helpers are your backups, right? So if something happens next month to you, who you don't think about 10 years from now, we got a maintenance plan. Who do you trust managing assets or making healthcare decisions if you're not able to do that, right? And if something happens, if you're married, if it happens to both of you at the same time, who are your backups, right? You don't have to come up with the absolute ones. If you are struggling with that, think of some candidates and we'll talk you through it and get to the right candidate. Do I have a current inventory of assets? Like I said, a big part of estate planning is making sure we get those assets securely and smoothly over to wherever we need it to go. What advisors can I involve in the planning process? I think financial advisors are great. Tax advisors are great too. Financial advisors I find more in tune because they're on top, have a pulse on all of the assets. So it's really great to work with them if you have one. Am I willing to meet the commitments asked of me? That's just basically making sure you fill out the forms and the like and that. So with that being said, are there any questions? You can unmute yourself. You can type a question in the chat. I don't see any questions. And so I will hang on here for about another minute or so. And then thank you everyone for your time. I'm Bobby Feisee, president of Insight Law, and hopefully we got some good education on the estate planning side today. Yes. Yes, absolutely.
Is there any way to get any copies of the slides that you put up?
Oh yeah, this was not sent to you. I'll make sure that Michelle
No, I
sends.
didn't get, actually, I got nothing sent to me, no packet or anything.
Oh, okay. Yeah, absolutely, Karen. I will make sure that you get
You talked about a packet and maybe I missed something. I don't know.
You should have sent that with a PDF that had our bios and then our slides here, and that's selecting and working with an estate plan. I'll have her send that out.
And look through your stuff, but I didn't get it.
Okay, I'll have Michelle send that out to you. Any other questions? Good question. And Michelle's on here, so she's on it. she'll make sure she'll get it to you. All right, very good, everyone. Thank you very much for your time. And if you do have questions in the future, that's fine. That's also for the discovery meeting. We'll make sure we address it. The big thing is, in our firm, is repetition is the key to retention. So we'll repeat concepts, and the idea is just make sure we get the right plan for you, for your family, and the like. So thank you very much. Have a good day.